Alex here with part one of the My Docket series. I told my viewers, I'd be waiting until I got 3,000 subs. I'm not quite there, but I think I'm at the point where I am ready to start it anyway. Pretty close to 3,000 subs as it is. And the reason I'm making this series is because my viewers learn best from examples. And this series, the My Docket series, is going to be one gigantic example. I'm going to go through every single filing in my case. I'm going to go through every single hearing. I'm going to go through it in chronological order so people can go through my case as if looking through a magnifying glass from beginning to end. And I hope that it's valuable. And I think it will be, not only because I got a positive outcome, but because I didn't use a lawyer. I think a lot of people, I know in Nevada, 40% of the people that go into family court do not have attorneys. I know most of my viewers do not have an attorney. Those of my viewers who do have an attorney have only had one part of the way through, don't expect to have one all the way through, and oftentimes their attorney's not answering all their questions, so they can learn a lot from my video as to what's going on and what to expect. Also, there is almost no advice out there for dealing with high conflict child custody cases. There is a whole lot of advice for dealing with child custody in general, for dealing with divorce in general, but there isn't a whole lot that fully grabs with both hands. And I'm not just talking about the whole helping you heal philosophical understanding of high conflict child custody and personality disordered exes or emotionally immature exes. I'm talking about help that specifically helps people turn the wheels of justice on their own. The fact of the matter is, if you're going to represent yourself in a high conflict child custody case, you can't use an attorney unless you have hundreds of thousands of dollars, often $1 million, because these cases don't end. They go on and round forever and ever. I've had so many viewers email me and tell me, yeah, I spent $300,000, $600,000. There's one viewer that I recall mentioning having spent over $1 million, and they're still not done. And so oftentimes people end up either burning through every single cent that they have and going into debt, or they end up representing themselves. And those are just the people that continue to fight. A lot of people just give up because they just don't see any end in sight. So I know that a lot of people are going to criticize the fact that I'm going into my specific case, but because there's nothing else out there, I'm going to go ahead and do it anyway. One of the things that I have not forgotten to this day was how absolutely and totally alone I felt in the process. Nobody understood anything about representing yourself in the family court system. Nobody had any advice that was useful at all. I did, of course, earlier mention that there is advice out there on dealing with child custody and divorce in general, but there isn't any advice on dealing with high conflict child custody and divorce. In my particular case, I didn't marry my ex, so I didn't have to go through a divorce, like a separation of assets and debts, but I did have to go through the child custody part of it. So there is a part 0 which has a whole lot of disclaimers in it. Please watch that video if you haven't seen it yet. Part 0 basically covers the fact that this is here for you as a viewer to learn from. This is not here for people to feel bad for me. I've already won my case. This is not here for people to worry about me. My case cannot be reopened. It's impossible. My ex's parental rights have been terminated. My son was adopted to myself and my wife, his stepmom. That means that the termination of parental rights is irrevocable. So don't worry about me. Don't feel bad for me. I had a very positive outcome. My case is over. I don't need friends or allies. I don't need people to join my cause or anything like that. I think a lot of times that's what these YouTube videos look like, and not this video specifically. I'm hoping that people learn from it, and I'm hoping that people don't have to go through what I had to go through alone with absolutely no examples to go off of. So with that being said, this is the first video, so it's going to cover my first filing. But before I get to my first filing, I want to go into sort of the way my life was at the time just prior to the filing, what was going on, what was I thinking, what particular stage was I at in my life. The first thing I want to mention is I was in college. I was going to the University of Nevada, Reno. I was studying computer science and engineering. I did eventually graduate, but at the time I was still studying. I was working at Circuit City. I was working about 20 hours a week. I wasn't making minimum wage. I think I was somewhere around like $11 an hour. I was working about 20-ish hours per week, so I had to live with roommates to really make ends meet to pay rent. And I also had food stamps, which was a big help with regards to having hardly any income, at least compared to a full-time worker who was making you know, the same amount of money per hour. So what I do recall from having been with my ex as to the sort of catalyst as to, and by the way, I say what I do recall because I really mean it. It took me a while to just remember everything. I had to like write a list down before I went into this video because this was back in 2008 and it's not all crystal clear anymore. But anyway, what I recall at the time was, and I think this is a big thing a lot of people hit, is there's no point in staying together to preserve a family that isn't actually a family. A lot of people, I think, grapple with this, this idea of, okay, maybe I'm not happy, but I should preserve the family, or I should stay together for the child. And in my case, staying together didn't actually really preserve a family. It was as if I was alone in a relationship. And also, when it came to being a father, I wasn't really allowed to be a father while I was with her. She had a way of controlling every possible aspect of not just my life, but his life. And so I didn't have the sense of if I leave, I'm going to lose something. I had the sense of if I leave, I'm going to gain what I haven't had all this time. Um, when I did eventually leave, it took 3 times. 2 times I went back for very brief moments before I was very quickly reminded as to why this wasn't possible. And then when I left the 3rd time, there were a few surprises that hit me that I want to warn my viewers about. The first surprise is that my bank account was drained. It was a joint account, so I guess you could say our bank account, but she went and drained all of the money out of the account and moved into a separate account. So that was a huge shock, and I completely did not expect that to happen. So for me to actually move out, I was basically, when I had left the home, I was homeless for just not really even a single day. I realized I was homeless when I couldn't go back and I had no money. And I was able to luckily use one of my credit cards to get an apartment very close to the university. I'm not sure if that's normal, and I'm not sure how I pulled that off if it isn't, because as far as I know, you can't get into an apartment with a credit card. But at this time, I was able to, and I was lucky. And I was able to sort of recover from that when I pulled a couple of paychecks from my job. But the first thing I want to warn people about is if you're dealing with an emotionally immature ex or a personality disordered ex, you better get your money out of the account. Don't be trusting. Don't think you'll just be able to live apart separately and, you know, share custody of the child while you figure out how you guys are going to go forward. What's going to happen is you're going to get backstabbed. So you should really analyze the way that your relationship was going while you were together and figure out, was it a toxic situation? Was there backstabbing, deceit, lies? And if so, you should seriously think about preempting these kinds of actions, and this one in particular, draining a bank account by going ahead and pulling your share of the money out first and putting it into a separate account, just in case. You don't want to end up like I did, and I got lucky that I could find an apartment with a credit card. I just, nowadays I don't know if that's possible, and I don't know how I pulled that off back then, but ordinarily you need like a money order or cash or something along those lines. So I do want to mention briefly that after the bank account was drained, later on it came up in court quite a while later, months later. My ex alleged that I drained the bank account, which was the most bizarre allegation I'd ever seen. I'm going to talk about that more later when that comes up later on in the series, but I did want to mention not only was my bank account drained, but then she turned around and blamed me for doing it. The next thing I remember is losing a lot of sleep. It's hard to describe it. It's like I could only sleep for 3 or 4 hours, and even then it wasn't actual real sleep, and this went on for months. It's hard for me to really put a finger on what it was, because I don't really think it was the thought of litigation that really gave me anxiety. It was the thought of not being able to see my son again. And this was mainly based on threats and, of course, on actions as well. Once we separated, I was not allowed to see him anymore. She basically decided that I was a bad parent and I wasn't reliable and all these other crazy things, like I wouldn't feed him or clothe him. And this is also after she had attempted suicide and lived in a mental institute for 3 days. And I took care of him just fine when she was in that mental institute. So it was just a ridiculous allegation. And the other part was the whole threat. There was the threat that because you left, now you're not allowed to see him anymore. This was particularly weird as well because she would contact my family members and tell them that I didn't want to see him and that I wasn't paying child support. And my mom, I remember calling me once and chewing me out about it. And I'm like, what are you talking about? None of this is true. I was paying a limited amount of child support, whatever. She didn't ask for a lot. She asked like $200 and a month. And then I also did want to see him. She just wouldn't allow me to see him. Later on, she did set up some parameters. For example, I was allowed to see him for 2 hours a week at a park, supervised by her. I would not recommend anyone allowing that. And ultimately I didn't allow it because I went and sued her. But if you have an ex who's trying to control the situation post-separation like that, they're saying that you can't see the child except for 2 hours a week supervised at a park, something ridiculous like that. Don't let that stop you from going to court, because it's almost nothing. Even the courts don't do that to somebody unless they are a criminal of some sort or they are addicted to drugs, serious drugs. If you have any kind of, I'm not even going to say functional personality, because even if you're dysfunctional, you still get substantial amounts of time with your child. You won't end up with joint physical custody, but you'll at least get every other weekend visitation. Most dysfunctional parents will still at least get one overnight. So for an ex to say you're only going to get your child 2 hours a week supervised, as I mentioned, unless you have a multitude of criminal convictions or you're a drug addict, there's no way that you're going to get it, that's what you're going to end up getting when you go through court. You're going to get something much more substantial than that. So a few other things I'm trying to recall now. My car, this was frustrating. She had my car, I don't know how she ended up with my car titled to her. I feel like it was something that, I don't want to say tricked into, more so guilted into. You know, a lot of people claim that control mechanisms revolve around threats of some kind of physical violence or emotional violence, but I think a lot of times it's not. It's guilt. And that's what she used most of the time to control me. It was guilt. And one of the things was that she wouldn't be able to drive her son around if she didn't have a car. And like I said, I can't remember 100% for sure, but I'm like 99% sure that I voluntarily signed over my car to her because of those fears that she had. So I had no car. I did get it back later. She signed it back over to me several months later once litigation started. But again, I'm going to preserve that, the details for that later on for when that actually comes up in this series. So I decided that I was going to file the petition to establish child custody and visitation without an attorney, because I felt like I had nothing to lose. Number one, I felt like I had almost no custodial rights. Number two, I was already paying child support. So it didn't really scare me to go to court without an attorney, because it was like, what's the worst that can happen? They're not going to take away this. This tiny little bit of time that I have is not going to be taken away. The only direction I can go is up. And all I was going to really go and ask the court for was every other weekend, and the same amount of child support that I was already paying. At this time, 2008, joint physical custody was not really a thing in Nevada. From what I learned, there was a 1997 decision that discussed the notion of awarding parents joint custody in the context of not rewarding a high conflict ex. That's the best way I can describe it. It wasn't very clear at all. The judges didn't really see that case as a case that propelled them to joint physical custody. And little did I know, at the time of all of my strife, there was actually a huge battle in the Supreme Court of Nevada going on about joint custody. It was the Rivero case. And I vaguely recall Rivero 2008 being published either shortly before or shortly after my filing of my petition to establish child custody. And that case was going to control my future. Little did I know that I owed everything to Mr. Rivero and I mean, I'm pretty sure that I wouldn't have ended up where I am right now had that case not published at the time that it did. So I'll talk about that more when it comes up. At this time, I wasn't really aware of it, so I'm just kind of explaining why I was just thinking I should just get every other weekend. That's what dads get. Dads never win in court. And I felt like what I had at the moment, which was supervised visits at the park, was less than that. So I wasn't really afraid of representing myself in court because I had almost nothing as it was. How did I go about doing it? No, in the beginning, I didn't have any understanding of the law at all. I did not know what paperwork looked like, how it had to be prepared. I didn't understand the point of any part of the process at all. So I went to the self-help center and I paid for a packet. At the time, it cost $3. I remember going to the courthouse. You had to go within a specific window of time. You had to go to a little booth. That is the first time that I met, I think her name was Julie Erkelin, but I cannot recall for sure. I'm 99% sure that that was her name. And this, I don't know even what her position was, but she staffed the self-help desk. This person was a person that I would get to know over the next several years. And I do recall years later, she ended up working in the law library, and I ended up going in there and seeing her and remembering her. And I remember telling her, hey, remember me? All those, times I was at your window getting packets from you and getting help and getting notary signatures and stuff. Guess what happened? I got published by the Supreme Court, and she was pretty shocked. But yeah, I still remember that woman, nicest person ever. Yes, she would give out packets. You'd have to pay $3 if you wanted a packet, and she would also help you understand what you were filling out. And she would also she was like a notary as well, a free notary. So if you were in a state that has a self-help center, you could probably use that self-help center in the same way that I did to get the packets and to get some help filling them out and also get a free notary. Now, I wouldn't tell people to use those forms. I tell most people that you should learn how to prepare your own custom forms if you're in a high conflict child custody case, because you just get taken more seriously. If you're in a low conflict case, you don't really need to learn all this stuff. You'll be able to get a few packets, fill them out with your ex, work through things for the first few months, and that's it. You won't end up in court again. Unless it's for something minor like adjusting child support. But in my particular case at the time, very early on, I didn't even know you could type your own papers up. I thought this was the way it was done. So I went and I filled it out, and I went and filed it. Here we have the petition to establish custody and visitation. This is a self-help form, so it contains a whole lot of blanks. I'm not going to go through each and every single blank that I filled out. Mainly that is because most of them are job application, bank application style questions in plain English that anyone could understand without any understanding of the law at all. And what instead I'm going to do is focus on the areas that jump out at me, the areas that I want to highlight for the viewers. I want to mention straight away that my handwriting isn't very good. If you are going to use one of these forms, make sure that you can write as legibly as possible for the judge, because the judge is going to be the one that reads through it. Even better, if you can get one of those PDF fillable forms, go that route, because typewritten text is going to beat handwriting any day, no matter how good the handwriting is. Going into some particulars with page 1, case number and department number here, you can see these are filled out. I just want to mention that this is not my handwriting. In fact, when you file a petition like this, those lines are going to be blank, and that's because you don't have a case number yet or a department number yet. The petition is what they call an initial pleading. It's that first piece of paper that, when filed, creates the case. And at the time of filing the petition, you'll be given a case number and a department number. The clerk will usually fill it out. I don't think they just tell you and have you fill it out. They'll usually take it from you and stamp it, or they'll handwrite it in like this clerk did on this paper. The code number in the top left, I want to bring your attention to. Not all courts use this. In Nevada, we only have 2 judicial districts that do, the 2nd and the 8th judicial districts. 8th judicial district is Clark County. They use letters. 2nd judicial district, which is Washoe, which is where I had most of my high conflict child custody litigation, uses numbers. This is a self-help form, so it's pre-filled. But later on, when I started to prepare my own custom forms, I always made sure to go onto their website and download the table of codes. And I would always find the right code number and put it into the paper, because that was just my way of doing that one extra thing that I felt a lot of other self-represented people wouldn't do. In fact, many other self-represented people wouldn't even prepare their own custom papers. So let's scroll down here. Oh, one thing to mention. This dollar sign right here in the front, that represents that this, I don't know why they do this. Not everyone does this. I want to stress that. That represents that this paper requires a filing fee. I just wanted to mention that I paid $141 when I filed the petition. The price, the filing fee has gone up a lot since then. It's over $200, but I'm not sure how much over it is. I wish that I had not paid it. In hindsight, I wish that I would have gotten a fee waiver, because at the time of filing this petition, I was barely making ends meet. I wasn't even working full time. I was making like $11 an hour. So had I known that fee waivers existed, that is something that I would have done, because I don't even know how I made this work. I don't know how I paid this. I must have gone with ramen and cup of noodle soup for like 3 weeks to make that happen. I was on food stamps at the time, so I know the situation was dire. Again, that's why I was representing myself. I couldn't even afford the filing fee. I had to scrape that money together. How in the heck was I supposed to get an attorney? Scrolling down here, we're going to skip over some of these basic questions that have to do with where I live, where the child lives, where they lived before, where I lived before, where my ex lives. Basic questions you should just fill out honestly. But here we have some paternity questions as to how paternity was established. You know, I should pause here and go over something. The purpose of the petition is twofold. Number one, you are making clear what relief you are requesting from the court. In this particular petition, I am requesting the court give me custody and visitation rights over this child. That's both physical and legal custody. The second thing is to list the allegations that entitle me to the relief I'm requesting. So why am I entitled to custody and visitation of this child? Well, here's a list of allegations, and it's quite thorough. It's where did I live? Where does he live? Where did he live before when we were together? Where does my ex live? Where does he live now that we've separated? How has paternity been established? All these questions have to be answered in the petition, basically by setting forth allegations. Later on in the process, your opponent or your ex will be able to refute some of those allegations. And then as the case proceeds forward, the court will be able to go through certain hearings and conduct analysis where appropriate and determine, whether or not you have shown that you're entitled to the relief you're requesting and whether or not you haven't. And oftentimes cases like these are not that clear. It's not really so much as who's a winner and who's a loser as who's going to get this type of custody, who's going to get that type of custody, who's going to get this type of visitation, who's going to get that type of child support. The petition here is just opening that doorway. It's giving the court the power over the child, over the case, over me. And the court won't have power over my ex until later. I have to serve my ex before the court will have jurisdiction over her. But at this point, at the filing of this petition, the court is basically being made aware as to what it is I'm requesting, why I think I'm entitled to it, and I am submitting myself to the jurisdiction of the court by filing this. So let's continue. This is interesting. So when I mentioned earlier that I was paying $200 per month in child support, I was just stating that based on my memory. So having read this line here, now I know for sure that's where I got that from. Well, what I mean to say is, now I know for sure that I remembered it correctly, because I wasn't actually sure. Health insurance, I was mentioning how you have to set forth the allegations necessary to show the court why you're entitled to the relief you're requesting, where does the requirements as to what that entails come from? That's a question. The answer to that question is statutes, rules, and case law, which I've talked about in numerous previous videos. There are certain things that the legislature has set forth that are relevant to child custody and visitation. And one of those is how the child is going to be covered, with regards to health. I think it may include vision and dental, but I'm not sure. For all I know, it's just health insurance. And that's why this question popped up here on the petition. The nice thing about having a self-help form is that usually everything that's filled out in the form is what is required for the court to be able to proceed in the case. If you prepared a custom form, a custom petition, and some of this information was missing, it's likely that the court would dismiss the petition without prejudice. You'd be able to come back later after you fix it. Sometimes people will amend a petition in the middle of a case. Like the judge will warn them that this isn't going to be enough for them to proceed, and they'll give them the authority to amend the petition and correct it and put in the parts that are missing. I went through this when I did the petition for adoption and termination of parental rights in my case, because I had to actually look at the statutes and find out what really is required in the petition for me to get the relief I'm requesting. And the reason why is because, number one, I was trying to move away from self-help forms to begin with. At year 6, I was done with self-help forms. But number two, there was no self-help forms in Nevada for termination of parental rights or adoptions. They just flat out didn't exist. So I had no choice but to prepare a custom petition. So I just kind of wanted to explain that. This might seem like something that's just kind of prepared by some rando at a courthouse, but it's not like that. The legislature sets forth all of the laws that apply when trying to get custody of a child, and somebody goes and prepares these forms to help people who aren't attorneys by reading through those laws and determining what kind of information they have to put in the forms and where they have to put the blanks and stuff like that. Okay, so here's an interesting area that I want to bring up to my viewers. This part here talks about custody and visitation orders that have been entered regarding the children prior to filing this petition. This can actually occur in some situations. In fact, many times it does occur. In my case, it didn't, so I just put none. But for example, if your ex went onto welfare and they were getting TANF, which is Temporary Assistance for Needy Families, TANF, oftentimes the welfare department will go after you and try and get child support. They'll institute proceedings, and usually, I'm not even sure, I'm fairly certain that when you end up being pulled into one of those proceedings, the judge will not just set child support. They'll also set forth some kind of visitation rights. Another situation where that can happen is they call them, a lot of people call them restraining orders, but in Nevada we call them orders of protection against domestic violence. A lot of people will file one of those, and then the domestic master in that case will grant or deny the petition, and then on top of that they will enter some kind of custody order. These orders that are entered in these types of situations they're not really like full-blown child custody awards. They're kind of just awards or orders to sort of set you guys up for now until you can sort out the custody and visitation issue at an actual child custody court, an actual in front of an actual real judge. I don't know about all my other viewers, but in Nevada, they're not even judges. They're called masters. The people that preside over the child support cases are called, I think they're called child support masters or child support referees. And the people who preside over the restraining order, again, it's called, the formal name is Orders of Protection Against Domestic Violence. The people that preside over those cases are domestic masters. And the types of orders that they enter aren't actually coming from a full-blown child custody dispute. It's just sort of, here, take this order for now and figure things out later. Anyway, if I had filed this petition after that had occurred to me, I would have to enter the details, of whatever particular master, whether it was a child support master or domestic master. I would have to enter the custodial details that master had entered into this line, into this paragraph here, just to let the family judge know in this child custody case that I just opened that there was already some kind of visitation rights or some kind of custody rights set up. I'm not even sure if I want to call them temporary custody rights because it's just weird how it works. It's weird how they go about setting up custody in those types of cases without actually going through the full panoply of discovery and setting an evidentiary hearing and a trial and hearing witnesses and stuff like that. Some people do bring witnesses to those types of cases, but it's never really a full-blown, thorough analysis as to what's going on with the family. It's just a really quick, okay, you want a protective order? Oh, okay, you want child support? Here, take your child support, take your protective order. Here's a really quick custody order, get out. It's a very different situation from an actual child custody case or divorce action that involves children. I want to mention here, a lot of people struggle with these areas. Up to the present time, blank has been the primary caretaker. A lot of people are upset because they feel that they're being excluded from the child's life. The other parent is hiding from them, not allowing contact. And so they'll enter funny little answers in here, like they'll say that they have custody or that they have joint custody. This isn't the time really to start contesting issues. This is the time for you to just set forth the facts of the case. And so it's important that you put the truth in for questions like this, as much as your urge may be not to, because it's not like it's going to be used against you. In fact, it may be more likely that it's used against you if you're a little bit deceptive. But you know, my ex was the primary caretaker of the child at the time that I filed this petition. It wasn't because I wanted it to be that way. She just kind of decided it and said, if you don't like it, too bad. But I still made sure to fill these out honestly because I didn't want it to come back to bite me. And I recommend that my viewers who are filling out these forms do the same. So here's the first area where you actually make your custodial request clear to the court. I requested joint legal and joint physical custody, which makes sense. See, this is odd. I don't know why I put yes here. I don't know how a person can ask for two of these different. So this here I would say is wrong, and I shouldn't have done that. Luckily, it didn't come back to bite me because I still put yes up here and let the court know that I wanted joint legal and joint physical custody, but I don't know why I put a yes in both of these spots. It's just one of the great things about going through the series is mentioning the areas that I made a mistake, and that's a mistake. I shouldn't have put that there. Here I discussed the type of contact that we've had with the child. Again, I really didn't go into like a character assassination. I mean, there's a paragraph here where I could go into detail, but I didn't want to do that in the petition because I knew that the purpose of the petition was to just basically state what it is that I wanted and what it is that was going on. I knew that I would have an opportunity later on to get into the details as to, you know, I should stop there. I didn't really know what my ex was going to say. So I wanted to wait until I read her answer to see if she was even going to contest any of this stuff. I was like 95% sure she was going to. But I didn't see the need to start attacking at this point because I hadn't even read any formal response from her yet. So I think a lot of people will do that. They will file the petition and they will fill out these blanks with all kinds of allegations and character attacks on their opponent. But you know what? The court hasn't even seen your opponent's response yet. So it's kind of like you're getting ahead of yourself a little bit. So when a question asks, you know, what's the contact that the parent has had, just answer the question. There's no need to go into all kinds of extra, yeah, but they're a horrible person and they do drugs and they, you know, there'll be other areas where you can bring that up. Not necessarily in this forum even. There may be spots in this forum, but okay, so this ends up coming up a little bit, and some of my viewers have complained about not having, I think this is in it, oh, here we go, the holiday schedule. Some of my viewers have complained about not having holiday schedules. In Nevada, this is typically included right from the get-go, right in the beginning, in the petition. And so I was able to describe the holiday visitation that I was requesting straight away. It's pretty boilerplate. These are all the typical holidays that people ask for, and you pretty much set up whether you want to take odd years or even years and when you start taking those holidays. So here's another area that's a little important. A lot of my viewers ask about vacation periods, mainly in the context of not even having vacation periods. What I mean by vacation periods isn't even really like the time to necessarily go to like Disneyland or something like that. It's just a time for you to say, I want this big block of time, like 2 or 3 weeks. Let's say normally you're week on, week off, or you have you split the week in half or in thirds or whatever. A lot of times people will want a chunk of time to have more intimate contact with their child over a longer period of time. And usually it's used to go travel like out of state or to an amusement park or something like that, but it isn't always. And I always stress the importance of setting up your vacation as soon as you possibly can. You're not your vacation, setting up your vacation orders as soon as you possibly can. And I just wanted to mention this because it's actually right here in the petition. So again, it's another one of those important things that is brought to the court's attention immediately. So at this point, I'm reaching the end of this pleading. By the way, if you want to know what the definition of a pleading is in Nevada, I have a separate video on it. It's called pleadings, or maybe it's just titled pleading. It's important because certain rules of civil procedure apply to pleadings that don't apply to anything else. I'm not going to really go into that in this video because it actually hasn't come up. Nothing has jumped out where the definition of a pleading matters. But for some of my viewers, if you want to look into that, you definitely can. It's especially going to matter in other types of cases where people can attack the pleadings. They can attack him in child custody cases too, but it's rare. In ordinary lawsuits for money damages, right away the defendant will attack the pleadings using certain mechanisms to try to close the case very early. Again, I'm not going to go into that in this video, but I just wanted to mention that. At the time, here I want to go over this. At the time that I filed this, I used a notarized notary stamp, notarized, whatever you want to call it, subscribed and sworn by. There's a name for this thing here. I don't know if it occurred after I filed this paper or if it had recently happened and nobody really knew about it. But in Nevada, we have something called the declaration in lieu of affidavit. And you can actually go about preparing a custom paper in a way that doesn't need to use affidavits if you know how to apply that particular statute. I should even stop myself there because I think a lot of the new forms that they prepared actually don't use affidavits anymore anyway. I think they all use the declaration in lieu of affidavit. It's basically a fancy statement. It usually gets put up around here or maybe, yeah, usually right here above the signature line, and it'll say, what does it say? Something like, I declare under penalty of perjury that the foregoing is true and correct, something like that. In fact, I have a video on affidavits or something like that where I go into it more. But if Nevada has this statute, I'm sure the other states do too. And I wanted to mention that here because it was always a pain to have to go and get a notary stamp, and sometimes they would charge. I'm not sure that the actually, I'm sure that the self-help center did not charge. It was free there. But if you went in somewhere else, they would charge. I didn't really care that much about the money. It was pretty cheap. It was like $5 or $10. But it was the time that was annoying. You'd have to make one extra stop just to get your court paper notarized. So if anyone is in one of those states where you have the power to just put a declaration in lieu of affidavit rather than an affidavit, but for whatever reason your self-help forms do not have that language in the form, that might be yet another reason for you to really start shifting towards custom forms, because there was a point at which I was preparing custom forms and using the declaration in lieu, and other people representing themselves were still using the old self-help forms and going out and getting affidavits, and it's just one extra thing. You know, it makes it easier for you, and if the law is there, you may as well use the law. So later on, when I go into some of my other forms, I'll be able to show my viewers exactly what it is I'm talking about. So this is a verification. Apparently in Nevada, complaints and petitions have to be verified by the actual party. This matters because otherwise attorneys could just file stuff and say, yeah, this guy told me he was okay to sue for them, and it could not be true. It might be a lie or whatever, and you may end up getting sucked into a case that you didn't want to and cause all kinds of problems. Of course, it's not going to stop somebody from forging your signature, but the purpose of the verification is for the party to verify, yes, I am actually the person that hired the attorney. Of course, in this case, I'm representing myself, so that logic doesn't really apply. but my understanding is that's why they use verifications in these. You're basically saying that under penalty of perjury, everything inside the petition is true and correct, blah blah blah. You've got the language here, you can read through it. And again, it's notarized, so there's a second notary section here. In fact, I'm pretty sure that they charge you per stamp, the notaries. Again, the Self-Help Center was free. I don't know if it's still free to get notarization there, but at the time that I went, it was free. In fact, I wouldn't be surprised if they don't have notaries anymore at all, just because they've all started to go to the declaration in lieu. So this is the affirmation. I've talked about this in a separate video. I just can't remember the title of it. But in Nevada, we have this statute, NRS 239B.030, and it requires an affirmation that whatever it is you're filing does not contain the social security number of any person, with extremely rare exceptions, one of which will come up, I think, in this video. When I check the other papers that I'm going to go over, I'll talk about it. But basically, it's just a simple signature and you once again swearing that whatever it is that you're filing doesn't have a social security number. That's all it is. If you do not include this, they will not be able to file your paper in Nevada. And this happened to me countless times. Countless times I would forget to include the affirmation. Later on, when I prepared my own custom forms, I didn't even use this piece of paper, this gigantic piece of paper. I would just add one line, like a one-line sentence, like around here. And basically it would say, rather than having a whole page dedicated to it, it would just say, the undersigned does hereby affirm that the preceding document or that this particular paper does not contain a social security number. It's just a cleaner way of including it rather than just killing an extra tree. So I guess with that, I'll go on to the next paper, which is the confidential family court information sheet. I'm not going to show the actual form because it's confidential. I just want to show people that this exists. And it is kind of a generic form, just like I mentioned earlier, one of those job application, bank loan type of forms that really you don't have to understand or need to know anything about the law at all to fill it out. It's just addresses, telephone numbers, driver's license numbers. It might even have a spot for social security number for all I know. I'm not going to look into it in detail, but I did want to let people know that this is one of the things that gets filed with the petition to establish custody. Next, we have the summons. For whatever reason, they don't keep the summons on file. This is the piece of paper that the clerk will give you after you file the petition. They will give you this piece of paper, and they'll put a stamp on it and a seal, a raised seal. What I mean by that is it'll have like a texture to it. And this is the piece of paper that you serve to your ex that will give the court jurisdiction over your ex. And as you can see, it says in bold, to the defendant, you have been sued. And it warns them that they've been sued and that the court may decide against them if they don't file a response. So once you have served your opponent with the summons and the petition, the court will have jurisdiction over them. So that's just one thing that I don't know why they don't have filed in the system. I can't download it and show it to you, but it's so basic that it's not really a big deal. So here we have the short form financial declaration. Again, you can see the code number on the top left. The short form financial declaration I filed at the same time that I filed the petition, otherwise I wouldn't be going over it in this video. And my understanding is that it has a whole lot less information in it. It's probably for people who don't have like real estate and maybe stocks and bonds and other things like that. I was just a college student working just like 20 hours a week. So I really didn't need to go into that much detail for my what was it, short form financial declaration form. I think they call this a financial disclosure now. I'm not sure that they use this form anymore. I wouldn't be surprised at all if they don't use this form anymore. But at the time that I used this form, back in 2008, I'm sure they had 2 or 3 different types of financial declarations. Most people now, it's just called the financial disclosure form or something like that. I'm not going to go over that because that's not what I filed. I really don't care if people know what I was earning back in 2008 when I was a college student. So again, this will be available as one of the links that you can download. And it helps people, it gives people a snapshot as to what I was earning at the time. If I really was concerned, I would keep some of this information redacted, but it's my personal information. It's from 2008. I really don't care if people see it. If anyone has any questions about it, they can ask. One of the things I recommend is to make sure you fill out the financial declaration truthfully, because if you don't, it is definitely going to come back to bite you. It's one of the first things that attorneys use against a person representing themselves or not. Most oftentimes, it's the person representing themselves who minimizes their income and inflates their expenses. And a lot of times, it doesn't even matter. Like, unless you're going to deal with like alimony or something like that, your expenses aren't even going to be taken into consideration. With child support, it's just based off your gross monthly income. So unless there are people out there who are aware of how to set up deviations to child support based on their expenses, then there's no reason as to why it would matter. And from what I've heard, that's just not something that's done. This is old. I don't even have this account anymore. Old bank account information. Old car. This car was ancient. It was like a 1990 Corolla. And here's the value, $1,000. So I didn't have a lot of debt, which is nice. Again, we have the affirmation. I think with that, I'm going to move on. So this is the personal case information form. This would have some of my ex's private information on it, so I will not disclose this one, nor will I include it in the description below. But as you can see, it's a form that's required by the Uniform Child Custody Jurisdiction Act. The types of questions that are asked in this form have to do with where you and your opponent have resided and where the child has resided and stuff like that. It's to help the court determine whether or not it's going to have jurisdiction over that child. And it's, again, the questions in this form are run-of-the-mill bank loan application, job application style questions. They're not legal questions where you have to go through legalese and figure out what terms mean and stuff like that. So that being said, I have gone through 5 different forms. I'm going to include 4 forms in the comments below. I hope that this example is useful. I really don't think it's going to be very useful to my viewers because it's just one of those things that is cut and dry, and there isn't any conflict at this point because we haven't gotten any responses from my opponent. But I'm going to go through each and every single filing, which is going to include the boring ones too. And just because I don't think it matters much doesn't mean somebody else is going to think that it doesn't matter much either. I have had a few questions from people who didn't even know what filing was, and I guess I could go over that now because this is video number 1. These pieces of paper, after you fill them out, you actually have to take them somewhere and file them. I know this is going to be a shock to some of my viewers, but there have been questions in my inbox from people who didn't even know that. They didn't know that they had to take this stack of papers to a courthouse and get a stamp in the upper right-hand corner and get a case number. And that's one of the things that you're going to have to do if you don't know that. Also, you are going to have to learn how to serve papers. You're going to have to learn whether or not you can do it yourself, whether or not you have to find somebody else to do it for you. I'm going to go ahead and talk a little bit about that because service of process was an ordeal in my case. My ex hid. She would not. Once she found out that I had sued her and I was trying to find her and serve her, she cut off all contact. No emails, no text or phone. There was a point where the only chance that I had to get her served was at her job. And that was crazy in and of itself. It took 3 different visits. The first visit, I was waiting there with the process server because, well, first off, one of the things I mentioned is find out whether or not you can serve them yourself. In my particular case, I could. In Nevada, and I'm sure most other states, another person over the age of 18 has to serve these papers personally, which is to basically physically meet and give the papers to the other person. That's what makes them able to do something like this, able to hide. There is a way to get around that. It's called service by publication, but I have a separate video on that. I won't talk about that in this video because that's not what I had to do. The first visit I had to go with the process server because I was afraid that he wouldn't be able to find her. The second time I went back to her work and she had one of the, she worked at the VA hospital. She had one of the veterans police come out and ask us what we were doing there. It's like, we're trying to serve her court papers. The third time, I went with the process server to the HR department, and the HR people found out it was us, and they were like, oh my God, she is not going to use this workplace as a hide-and-go-seek game. And they forced her to come down and take the papers. That was the best day ever, because I thought I was never going to have a chance to get her. Whatever happened with them contacting her boss or her supervisor, it worked, because she ended up coming down and the process server was able to give her the papers and we were able to leave. And of course, once she was sued, all of a sudden she wanted to start sending me messages and stuff again. I do want to mention that there was a few times that I tried to send the documents in an email, and that just made it worse, because she replied saying something like, I don't know what you're talking about, I can't open the attachment. It was like trying to play stupid, like, I don't know, I've been sued, you can't, I don't know what's going on. Like, it's a simple tactic, it's play dumb. So that's, I guess, another piece of advice I would give people is, if you're dealing with a high conflict ex, if you've been in a toxic relationship, if they're petty, if they're petulant, if they have backstabbed you or lied, stuff like that, it's not a good idea to warn them that you're trying to serve them like I did. I wish I did not do that, because it made it take so much longer, and it was a very stressful period. I thought I would be stressed at the prospect of going to court, but as I mentioned earlier, I really felt like I had nothing to lose, because I had almost nothing as it was. I was paying child support and I had almost no visitation and custody rights. I basically had no rights. So I felt like there was nothing to lose with going to court. So I wasn't afraid of court. What I was afraid of was not being able to get to court. And I lost a lot of sleep on the possibility of never being able to serve her. And so whatever you do, if you think you have a high conflict ex, don't warn them, because it's going to make it more, it's going to create more conflict, because then they're going to start playing hide and seek, and the tension is going to be even higher than it would have been if they would have been served by surprise and shocked, which it sucks. It sucks to get served out of nowhere, and it's a jarring experience, but just like that, it's over and it's behind you. But when you're playing a game of hide and seek with court papers, it just drags on, and the tension builds up and it builds up and it builds up. If I remember correctly, it took me like 3 weeks, maybe longer, to serve her. I'm going to end up going into one of the other papers that I filed, a proof of service, and when I get to that point, I'll be able to talk a little bit more about that. But at this point, I'm going to go ahead and go into the aftermath, which is to keep a tally of the costs and fees that have been paid. I'm going to keep this running tally all the way through my case, so I can give people a total as to the costs and fees that were spent in litigating this entire case, both for me and my ex. So at this point in time, I have spent $0 in attorney fees. I have spent $141 in costs. My ex has spent $0 in attorney fees, and she has spent $0 in costs. So if anyone has any questions going forward, definitely post them in the comments below. I hope everyone's excited to see how this series unfolds. And with that being said, I will see you guys next time.